counsel ready?
Yes, Arif.
Is defendant counsel ready?
Yes, Your Arif.
We will now hear opening statement from plaintiff counsel.
Ya Arif, my name is Nadia from the firm Tetuan Luk Maizura, and I appear behalf of the plaintiff today, Puan LAILI Abdullah, IC number 750503105182. So our purpose today before Yang Arif is to submit that the contract for the transfer of the land between Faris and Ain is void due to the failure to prove the existence of consideration in the form of natural love and affection between the involved parties. So therefore, we seek an order from the court to declare that the said transfer of the land is invalid. So Yang Arif, before I go deeper into the legal issues, allow me to explain how this conflict began. So on the day of the incident, the plaintiff, who is LAILI, and her brother Arif were running their business as usual. They also had settled and operated their business at that location for almost 25 years, Yang Arif, since before any other parties intervened in this case. Suddenly, Yang Arif, the second defendant, who is Nurul Ain, appeared. She was a complete stranger to the plaintiff and was not registered owner of the land. Without giving any notice to the right to be heard, Ain entered the business area and began instructing her workers to demolish the shop. The shop structure itself, Yang Arif, that Arif himself had built in the land, in the said land. Arif actually tried to stop them, and argument arose, shouting, chaos, and before anything could be halted, the shop structure was destroyed, and as a result, Yang Arif itself suffered a huge loss and lost his source of income. So the plaintiff was very shocked. How could a person who was not the landowner suddenly have such authority on the said land? The answer emerged later. The first defendant, who is Faris, had transferred 3 out of 56 shares of the land to Ain on the grounds of love and affection. So Yang Arif, this is the basis of our claim today. So pursuant to section 26A of the Contracts Act 1950 stipulates that an agreement made without consideration is valid only if there is natural love and affection and the parties stand in near relation to each other. So in this case, Yang Arif, I have conclude three elements or three grounds in this case, which is Faris and Ain itself have no blood relation, there's no family relationship between them, and their relationship does not satisfy the requirement of standing in near relation to each other. Therefore, Yang Arif, the transfer of the ownership of the land was made without consideration, and thus it is void. Thank you, Yang Arif.
We will now hear from defendant counsel.
Thank you, Yang Arif. Yang Arif, my name is Nur Hafiz Nurul Hadi from the firm of Tetuan Hafiz and Hazlina, and I represent the second defendant, Nurul Ain Abdullah Halim, IC number 88022314145900 in this matter. We appear before Yang Arif today to object to the plaintiff's application, which states that no natural love and affection exists in the land transfer. We will submit the valid consideration did exist because the relationship between Faris and Ain satisfy the definition of standing near relation under the Contract Act 1950, despite point Ain being considered an outsider. Therefore, we hope that this honorable court consider the existence of the element of natural love and affection and declare the land transfer to be valid. Yang Arif, with your permission, the plaintiff claims that Ain is an unknown person or a completely stranger. This is not true. For the court's information, the first defendant, Faris, transferred the 3 out of 56 shares of the land to the Ain because he owned a debt of gratitude to Ain. Ain had helped Faris when he was in distress. Therefore, Ain is not a stranger. She has a relationship of trust with Faris, which explains the basis of the transfer of the ownership. Thank you, Yarif.
So now proceed with the argument from both sides.
Yang Arif, may I?
Yes, you may.
Yang Arif, if a feeling of a debt or if a feeling of debt of gratitude exists, it does not satisfy the requirements of Section 26A of the Contract Act 1950. The relationship between Faris and Ain is not as intimate as intended by the law. Standing in near relation according to that section itself or that provisions refers to relationships that naturally lead to love and affection. This love and affection, I can give example to this honourable court, such as parent to child, husband to wife, or grandparent to grandchild. This is 3 examples that I can give. This aligns with paragraph 12 of Schedule 2 of the Real Property Gains Tax Act 1976, which also interpret the definition of the meaning love and affection within the context of family relationship. Therefore, Faris and I are merely friends, not family, Yang Arif. Therefore, no consideration exists in this case, and the transfer of the land is void.
Yang Arif, I appreciate plaintiff's argument, but it is misguided. True, Faris and Puan Ain have no blood relation. However, Section 26A has never mandated a blood relation as a requirement for validity. The law only states natural love and affection and parties standing in near relationship to each other. Near relation is not limited to consanguinity, which is a blood ties. It also encompasses first, a close relationship, second, relationship of trust, a third, relationship where one party looks after the welfare of each other. The court has already decided in the case of Gan Senki against Yap Yot Line 2015, in which we draw the court's attention to the High Court ruling in the Gan Senki against Yap Yot Line, where it was explicitly held that where blood relationship is absent, affection cannot be presumed, but it does not mean that it cannot be proved. This shift to the entire focus from a genealogical test to a factual burden of proof. The court ruled that the close friends can also fall under the category of natural love and affection if there is strong evidence of relationship categorized by love, support, and trust. In our case, this relationship is clear because first, Puan Ain provided extensive welfare and financial assistance to Faris. Number 2, their friendship has been consistent and close for a very long time. 3, Puan Ain regards Faris as a brother, and Faris admits that assistance stems from love and concern, which is this fully satisfy the meaning of natural love and affection, Yang Arif. Therefore, consideration exists and the transfer of contract is very valid. Yang Arif, thank you.
Plaintiff's counsel, the court will now hear your submission on why the plaintiff's claim should be allowed. Please comment.
Yang Arif, the law cannot be relaxed on the grounds of sympathy or friendship. Natural love and affection has a stricter threshold. Without a family relationship, this transfer of the land does not actually satisfy Section 26A of Contracts Act 1950. Therefore, the transfer of the land is void, Yang Arif. Thank you.
Thank you, Ms. Nadia. The court has reviewed your submission.
Defendant counsel, please proceed with your submission in rebuttal and defense on behalf of the defendant.
Thank you, Yang Arif. Yang Arif, again, I repeat, the law does not limit natural love and affection to blood ties alone, which is a close friendship accompanied by welfare and financial assistance provide a solid basis for a transfer without consideration. Therefore, this transfer is valid. Thank you, Yang Arif.
After hearing the arguments from both parties, the court believes that there is an existence of consideration between Faris and Ain. Even though there is no blood relation, the evidence shows that there is an existence of close relationship, a financial assistance, welfare support, and a consistent bond of friendship. This satisfies the meaning of natural love and affection under Section 26, subsection A of the Contracts Act 1950. In this case, the court believes that standing in real relation is not limited to blood relation. The court accepts the principle established in Gan Senki and Yap Yok land that blood relation is not mandatory requirement. What matters the most is the evidence of genuine love and affection. Therefore, due to the fact that no element of fraud or any caution was given, the registration is considered as valid and cannot be challenged. Therefore, the court finds that the contract is not void. Since consideration does exist, the contract and the transfer of the ownership are valid. Thus, the plaintiff's claim is dismissed. The court overruled the originating summons with the cost of 2,000 ringgit paid by the plaintiff to each of the defendants.